Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. Welcome back to the Legal Lounge. I'm excited to be back with one of our attorneys and certified mediators, Deb Dilman with the Modern Legal Team. Welcome back, Deb.
Thanks for having me. I'm looking forward to being with you today.
Yes, and today's topic is mediation. And mediation, I feel it's floated around out there in the ethos, but I don't really believe most people understand the dynamics of mediation, and most importantly, how mediation can help families when they're going through a family law dispute specifically.
Yeah, that's an interesting question, because I think also that when people hear the word mediation, they automatically think compromise. And in so many instances, folks don't want to compromise. But what they don't understand is that there is compromise and negotiations, and that's what it's about in conflict resolution. However, it's both sides are compromising. It's not one or the other.
Yeah.
So yes, I think that attorneys a lot of times don't properly explain that mediation concept. Contextually, it's conflict resolution, right? And you have conflict resolution from the minute you get up in the morning until the minute you go to bed at night. And maybe even when you're dreaming, you're dealing with nightmares and whatnot. But it's compromise and negotiations on both sides. And the beauty of mediations is that it allows you to remain in some control over what happens to you, whether you're in litigation, whether you have a legal dispute, or whether you have a family dispute of some sort. Mediation allows you to remain in control, and it's probably the last opportunity that you'll have if you're in a legal dispute with family law to remain in control. And holistically, if you think about it, long term, if you can remain in some control and the other side can remain in some control, and you have kids, then you're vested in the outcome. And the idea would be that holistically, then you're able to easily, or easier maybe in some ways, repair the relationship that you now have with this other person to raise your children, the business relationship.
Yeah, I can't agree more. It's interesting you say that, because I think sometimes people getting into these conflicts, especially when emotions are high, and especially when they want to prove a point, or especially when they believe they know what should happen, or what should happen with the kids in particular. And it's always interesting for me, because I feel like individuals think they have more of a say in a courtroom, when in actuality they have a lot less say, because what you're doing in a courtroom is you're presenting evidence of what you believe the facts are to be from your version of the story, but so is the other side. And then the judge decides what the facts are and what we're doing moving forward. Not you, not the other side, the judge. Whereas in mediation, it is the parties that are actually making the decisions on what the next steps are. And we're talking, notable issues here. We're talking when you get to see your kids, what the parenting arrangement is around the holidays, possibly which doctor the child goes to, or if the child is enrolled in different forms of therapy or medication regimens. And that's just the child side. What about the money side? A judge could very well tell you, you got to sell your house. And how, I I can't think of a situation more invasive than that, than when a judge can tell you where you're going to live, how you're going to spend your money, and when you're going to see your kids. And so to release that authority to a courtroom and to a stranger versus at least attempting the process at mediation, I feel like not enough people take advantage of mediation.
Yeah, I agree. And I think that what we also forget is if you do a deeper dive into it, when you have a legal dispute, there's both the emotional side and the legal side, right? And there's no courtroom or judge that can address the emotional side of your legal dispute before you get to what the law is. That's what they're skilled at doing, is dealing with the law. The law says this is what we're going to do. Where if you're in mediation with a good certified mediator, that mediator will be able to look at, okay, what are your interests? What are your needs? What are your fears? Judges don't care about that, but you do.
Yeah.
You person that I'm representing, you mediator does, and your attorney should care about that as well.
Yeah.
Because I believe that if you don't focus on the interests and the needs and the fears of the parties, then you're never going to get a law or legal result that anyone is satisfied with. They're both going to go away angry. And you don't have to do that if you're in mediation.
Yeah. And go one step further, if individuals are not satisfied with an order or a legal outcome, then chances go by the wayside of compliance.
That's right.
And then you're fighting not necessarily about the contents of the order itself, but then enforcing the order, or what does the order mean? Interpretation is a big issue as well.
Right.
Whereas if you're negotiating it and do resolve it in mediation, there's a lot of clarity because you have talked through and worked through these issues probably over a number of hours.
Yes, absolutely. And you can be much more creative in mediation than you can be in front of a judge. The judge is just restricted, and attorneys are bound by the law as well when you're in a courtroom. So you can't do some of those creative things like, I don't want to sell the house now. I want to sell the house in 10 years when the kids graduate from high school. Okay, in mediation, you might be able to work that out in some way. A court's not going to do that. They're bound by laws that require, property to be distributed within 6 years, right? They can't delay that legally, and so they won't.
Yeah.
So it's very complicated.
Yeah.
I think that we're in an environment now where people want and feel the need to fight to protect themselves.
Sure.
But I think that if you can step back from that, mediation is more cost effective than protracted litigation. It's also less expensive. And so, there are really some good benefits to going to mediation, but you have to be emotionally prepared for it.
Yeah.
And compromise, conflict resolution.
It's interesting you say that about creativity versus what a judge can do. I was actually talking to a judge the other day, a former judge. She is now back in private practice, but I remember her and I having a conversation when she was on the bench, and I asked her, I was like, what is the perspective of being on the bench versus being a litigation family law attorney? And one point that sticks with me through today is she turned to me and she's like, Theresa, I'm so bound by these laws that there's only so much I can do. And she almost felt like shackled, where she wanted to be more creative for the parties. And as an attorney, she's like, there's so many different ways that we could have structured an arrangement. But as a judge, she just couldn't do it. And I almost, when I'm talking to my own clients, I feel like clients will be like, well, the judge can do anything. And I'm like, actually, no, it's the exact opposite.
Right.
If we negotiate and come up with an amicable resolution, can do almost anything. Right. But a judge actually can do a lot less than what people think.
Yeah, absolutely. I mean, and I don't know how to force people, I guess, to understand the benefits of mediation, because you do remain in control and you can work out schedules that a judge would not necessarily be able to do. It's really, really difficult when you've got one party that's willing to go to mediation and then you have another party that's not. And so most of the time mediations are voluntary, or they should be. You want to try and get in before litigation. But if you have one person that doesn't want to do it, you end up in court. And then what happens in court? Somebody comes out of court feeling they won, and somebody comes out of court feeling they've lost. And now you've got this ridiculous power imbalance that you then have to deal with. And if you have children, young children, that's extremely, extremely hard to overcome.
Yeah.
Where if you're in mediation and you're compromising and talking about what's important to you, chances are you'll come out with a result where you don't have that big of a power imbalance. There still may be, but it won't be that obvious to everybody.
Yeah, I'll push the buck on that too. I think that's honestly the job of a good certified mediator, is they're there to really make sure both sides have a voice in the back and forth of the negotiations. And the mediator, certified mediator, let me point that out, will have the training and a toolbox, if you will, with different tools to push and pull both sides to not necessarily convince one side of what's right and wrong, but rather to, with the end goal being an amicable resolution, to push and pull to get us to that end goal.
Right.
And that's always an interesting situation. I remember a case, I may have mentioned this story on this podcast previously, but I remember a case where I was the mediator, and one side, I believe it was the mother, wanted the child in therapy, had sent over some therapists to the opposing side, but he never responded. So then I went to the other room, and the gentleman, he was like, well, clearly the child needs to be in therapy, but I just got a list of names. Who are these people? And it was not even that they had a disagreement about the child being in therapy, and rather it was just a miscommunication issue.
Yep.
And so a mediator is literally trained to help dissolve any of those boundaries of communication to get at the core issues. And it was interesting. I kind of felt like they looked at me like a hero when I was like, the opposing side agrees to therapy, when I was like, no, both of you had already agreed to this on your own. And so it's amazing from my perspective to see how many issues parties actually agree on. They just have to get out of their own way, and a mediator can help do that.
Yeah. And with respect to therapy, to your point earlier, if it's a permanent custody hearing, a judge cannot order therapy.
Yep.
She can only order, or he can only order therapy in a temporary situation, because they lose jurisdiction once the custody order is entered. So that's yet another reason to try mediation if there are some of those issues going on.
Yeah.
So, and you brought up a certified mediator. You've said that a couple of times. So it's interesting because in the state of North Carolina, for property distribution, you are required to do some sort of alternative dispute resolution process. If you choose mediation, it must be with a certified mediator, or you can be ordered to return to mediation. So for folks that are considering mediation, I think it is important to actually go on the Dispute Resolution Commission's website and see who is certified versus going to somebody that's local to your city that may not be certified, may not understand the local practices, may not understand what our judges can and cannot do. They may, but chances are they don't, because they're not involved with court cases every day.
Yeah. And specifically family law court cases.
Yeah, absolutely.
It's so unique to every county. And I guess just some further explanation for the listener. So the North Carolina State Bar is a regulatory body that basically licenses attorneys. So if you ever have a question of whether or not an attorney is licensed and in good standing, you want to go to the NC State Bar website. But similar to Deb's point, the Dispute Resolution Commission, which we phrase DRC, is the regulatory body over certified mediators. So same situation. If you're looking for a certified mediator in your area, they have a number of not only tools, but an actual directory, so you can find a certified mediator in your area.
And the Dispute Resolution Commission is governed by the judiciary, and part of our administrative offices in Raleigh. But yeah, so if certified mediators are attorneys and certified mediators, they have dual regulations that they have to comply with, and they're not always consistent. Yeah, I mean, they may be conflicting. So you have to be careful with that too. But the point being that if you do want to do mediation, which is an awesome thing to do, you should look for somebody who is certified to mediate your case for you in the county in which you live. Yeah,
that's a great point. So shifting to the concept of having an attorney in mediation, I'll first point out for the listener, to have an attorney by your side is not a requirement. However, as certified mediators, we highly recommend that you have an attorney by your side. And it's less about, I get it, attorneys are expensive. A private certified mediator is a cost as well. But there are going to be legal questions that arise in the mediation. And even if your certified mediator is also an attorney, they're not your attorney. So they can't give you legal advice, even though these legal questions are arising in the mediation process.
Yeah, absolutely. So the certified mediator, no matter if they're an attorney or not, they're not allowed to give legal advice. That's just not what the role of the mediator is. The role of the mediator is to be a facilitator. So it's always helpful to a person that wants to mediate to have an attorney that can provide legal advice, or to at least have somebody on the phone, call a friend or whatever, that you can get legal advice from, because the mediator can't give it. What the mediator can do, which is sometimes helpful, is pose questions that makes the person you're posing the question to think about what the law might be. But we, as a certified mediator, we simply have to sit on our hands.
Yep.
Sometimes the attorneys will ask us to weigh in on an issue, and we are allowed to do that if asked, but we cannot outright give any kind of legal advice, which becomes difficult if you're not represented and you don't understand the law.
Yeah. And go one step further, in family law specifically, there are so many nuances and gray areas that it is helpful at times if both parties have attorneys, and then you also have a certified mediator that also happens to be an attorney, to just float ideas or float experiences in a particular courthouse or with a particular judge. And that tends to help as well. Like another tool in that toolbox I was referencing earlier, to help at least the parties in this particular case find an amicable and creative resolution.
Yep, absolutely. It's also true that the attorneys can be a hindrance.
That's true too.
Because there
that
are attorneys that are all about litigating and not about negotiating, and will get in the way of what their own client may want or need from an emotional perspective, which could get us to a resolution. But because the attorney is so focused on litigation and what the law will do, some attorneys have a hard time sitting on their hands and listening to that.
Yeah.
Which becomes complicated for a certified mediator like myself, because if you read the room, which I think I do fairly well, you can see when there's a little bit of conflict between an attorney and the client.
Yeah.
And so a lot of times I'll shift my questions specifically to the client and attorney, hang on a minute, let me ask this question to see where we can get. And then, we can pull the attorneys out and talk to them. So there's lots of options to allow us to get through it. So yes, there are good attorneys. Attorneys should be helpful to a person when they're mediating, but sometimes you have to remember that this is your life, your case. And if your attorney is getting in the way, you need to be strong enough and brave enough to say, okay, attorney, let me talk for a minute. Let's talk this through.
And really convey your desires. I guess, flipping the coin for a moment, I have been the attorney representing my clients in a number of cases.
Me too.
And I'm sure you've seen it where, I think we can get more in a courtroom. I think we can get more parenting time or bring up some concerns in a courtroom that I think a judge should hear. But at the end of the day, that's not my call. It's not my family. It's not my money. And so, attorneys have to bite their tongue sometimes, but not all attorneys know to do that.
Right. Or they don't want to.
Yeah,
that's true. They want to go litigate, and that's okay too.
And normally there's not as many I can think of in Mecklenburg County, but the one or two I've heard will just, I guess, poo-poo on the idea of mediation.
And just check the box.
And it's a check box. They show up, they say they've been there, and then they leave, not realizing that a huge opportunity was just missed.
Right. Absolutely. And it's unfortunate, but it does happen. And, we work through that the best that we can.
Yeah.
There's no conversation more romantic than discussing a prenup with your partner, right? Okay, maybe the song for your first dance does a bit more in the romance department. Speaking of emotions, though, the prenup is a very legal document that everyone has a very emotional reaction to. Many people avoid the prenup conversation because they feel it is an indication that the marriage will fail. But here's the truth. Half of all marriages already fail, regardless of whether the spouses had the prenup conversation or not. If you or someone you care about is getting married, would knowing what marriage involves legally be important? What about having the difficult conversations surrounding finances, career aspirations, and pursuing parenthood prior to the wedding date. If you are looking to build a solid foundation for your marriage, or you want the same for someone you care about, we are here to help you learn more about prenups from a position of knowledge, not emotion. To learn more about family law from a legal professional, book a consultation with a member of the Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal services at modernlegalnc.com.
Now, aside from attorneys, which can be a resource during the mediation process, I would say more times than not, especially if you find an attorney that really is fitting to your desires and addressing your needs, there are other professionals that can be brought in on the process.
Yep.
So just to name a few, we have what we call a CDFA, Certified Divorce Financial Analyst. So as the name sounds, it's to analyze the finances and all the money. We can bring in a therapist, especially as it relates to the children, a child therapist. And it's not so much that that therapist would be a treating therapist to the child. It could be more so a therapist that is working with the parents to make sure that we're developing good co-parenting skills.
More in a coaching role than a therapeutic role. Yep.
Yeah. And we can even add provisions to a resolution that makes sure that parents are taking those steps to co-parent as best they can, despite being on adversarial sides.
Yep.
And we've brought in an accountant. I've brought in business valuators before. We've even had a certified divorce lending professional to run numbers on one party being able to afford a refinance on the house, because we needed to know in real time whether or not my client could keep the house, and a refinance would be required to do that. So I think it's important to realize that you can bring a lot of resources in at the appropriate times.
Yep. You can bring in a real estate professional if it looks like the house needs to be sold.
Yep.
You know, there are folks in this area, all over the state actually, that are certified in divorce real estate, so they remain a neutral, just like the divorce lending professionals. They're somewhat neutral in the work that they do, which is helpful sometimes when you have parties that, you know, are really reluctant maybe to sell a house. But, you know, there are lots of professionals, and we all have folks on our speed dial, you know, that during a mediation as a certified mediator, I can call and say, okay, this is the scenario being floated. Is this even possible?
Yeah.
You know, because I don't, you know, I think I'm smart. You know, I know the law and I know mediation and how to work with people, but I don't know real estate. I don't know mortgage lending. I can't do a financial analysis like someone that is skilled in wealth management to do that. It's out of my toolbox.
Yeah. And so we got to bring in those professionals to fill that tool in the toolbox. Now, I will note here, love bringing in other professionals that help. We have to be cautionary to anyone or any third party that thinks they are an area, quote unquote, expert, such as the relative that got divorced last year or other third parties. And it's not that I object to a third party being present like across the board. If they're helpful, especially to the emotional aspect that you were referencing a moment ago, then let's bring them in. But as a certified mediator, I am going to reserve the right to kick someone out if I can tell by reading the room that things are not flowing as they should.
Yes, and I do that too. My preference is for everybody to know if there's extra people there that aren't related to the case, but I don't always do that. But what I do regularly is with the third party, I make direct eye contact. It's you and me, we're talking. If I think you're helpful, because I'm in control of the day, if I think you're being helpful, great. If I don't think you're being helpful, I hope you have car keys, because you're not going to be able to stay here. Like, it's just, you don't get to control that. And I have had situations where I've had to turn around to the third party. I'm like, why are you even here? And it was clear then that money had been lended. And so she was there, not necessarily for the emotional support, but to make sure that she got her money back in some way. And I'm like, that's not really helpful.
And that's a conflict, I would say.
I think.
Because at the end of the day, we're trying to resolve this dispute between two parties, not another
Not
financial
a third party.
dispute.
Exactly.
with
Not a third
party
party dispute.
Yeah. So talking a little bit more about the mediation process. Yes, an individual can reach out to a mediator before they file a lawsuit. And even if they don't have an attorney, again, check out the DRC website. On the flip side, what we generally see in our industry is someone will have retained an attorney. Hopefully both sides have retained an attorney, and they'll reach out to a certified mediator. Certified mediators will generally block most, if not the whole day for the mediation. And the hope is that we're able to resolve everything on that day of mediation. So unlike other processes, which could be a couple of days, a lot of mediations are scheduled and do resolve themselves in one day. However, there is a lot of prep for that mediation day, hopefully. So this is not every case, but at least as an attorney in my cases, I'll try to make sure I get my client's documents, any documents that are relevant to the issues that we have at hand, whether that's we want to make sure the children get to school on time. So let's go ahead and look at the attendance records. Let's look at the school calendar. Let's see when they have to be at school. It could be financial circumstances. So let's exchange bank statements. Let's exchange mortgage statements or credit card statements. Let's try to get a value on the house if we think that the house is marital property subject to distribution. And so generally there'll be some type of voluntary document disclosure, especially if there's no litigation yet. And both sides should review that and then come to mediation prepared to discuss everything that they have learned about in this voluntary information and document exchange process.
Yeah, in an ideal world, yes, that should happen. And then if there are attorneys, you should create some sort of spreadsheet that outlines what's important to you. So from a property distribution standpoint, I should, as the mediator, I want to see a spreadsheet that outlines what assets and liabilities we're talking about. And if you have the value, great. Better yet, if you've had a conversation with the other side to make sure, one, you guys agree that these are all the assets and liabilities. And if you do agree, yay. Do you agree on the values? I mean, it doesn't have to be an affidavit, but some sort of spreadsheet that gets us started. Because the more that the parties can agree on things, the more efficient the process is and the less expensive it is for you. So preparation is key, and we hear all the time as certified mediators, and we experience it, I'm sure you do too, where people just come and they're not prepared. And not being prepared doesn't mean I don't have to have a financial affidavit. Frankly, I prefer not having a financial affidavit because people get stuck in the weeds. We don't need to do that. I don't need to have an equitable distribution affidavit. That's not helpful. What's helpful is some sort of spreadsheet that we can visually look at to see where things are going and what kind of distribution we may need to make. And then with the kids, yes, be prepared. Are they doing okay in school? Are they on time? Are there issues there that we need to talk about? Are there behavioral issues you're experiencing because of the divorce or separation, or is there something else going on? Just those things to think about. And then you have to come to mediation with an open mind that you want to get it resolved. But you also, in my opinion, have to go to mediation with your bottom line. You have to know what you're not willing to go below. So you've got your best and you've got your bottom. And I think it's important for the parties, not necessarily the attorneys, but the parties to understand what they're willing to do to get the case finished. And a lot of times they haven't even thought about that.
And when with family law, we also want to think of, I put them like different buckets, right? So if you absolutely want the children on Christmas Day every year, then we may have to release somewhere else. Maybe the other side gets Thanksgiving every year.
Compromise,
right? Exactly. That if we can't share this equally, and you want something, and that's your stake in the ground, there's nothing wrong with that. But then there has to be some leeway to allow for compromise to come out. Because if we don't, guess what's going to happen? We're going to go in front of a judge. And a judge is going to decide, and a judge is not going to get so creative where one parent gets one holiday every year. They're just not.
No, not unless there's religious beliefs that would allow that to happen, which is, it can happen, but it's not frequent. I mean, the same is true. You get a lot of people that are married to their house, right? They want to keep their house no matter what. And as attorneys that are practicing as mediators as well, you can kind of look at what's going on. You've got somebody that's maybe a school teacher and makes maybe $40,000 a year, not a lot of money, and how are you going to afford that house? Well, I can pay the mortgage. Yeah, but it's not just the mortgage. It's A, B, C, and D. So you have to give some thought to your goals and what your objectives are. And, if you're willing to be married to a house instead of married to the person, then fine.
Yeah.
And I've had that happen where someone was adamant they wanted the house. And then she contacted me about 2 years later, and she's like, you were so right. Like, I unloaded that house. I just couldn't afford, I could afford it, but I was not able to do another thing. And I'm like, yeah, is that worth it? Probably not.
Yeah.
So it's just, you need to prepare yourself. You need to be ready for it. Whether it's pre-litigation or you're mediating after you filed litigation, it's the same process, right? We can still be creative in mediation. You just have some deadlines that you may not have otherwise, but you still have to prepare for it. You have to understand what you really do want, what your biggest fear is. Let's talk about your fear. It's money. Most of the time it's money. If it's not money, it's a fear of losing and not having all the time with the children.
Yeah.
Those two things are the biggest fears we see, and usually it's on both sides.
Yeah.
One of them is fearful of about not having enough money, and the other one's fearful of having to give all the money to the other person. So the fear itself is very similar.
Yeah.
And then you just have to bridge that. Let's figure out how to make that work. We can do this.
Yeah. And let's take an honest look of the financial circumstance. Let's take an honest look at what's going on with our kids. And when you're able to have those honest conversations and confront those issues, because mind you, there's prep to mediation, and the mediation day itself, please don't come to mediation expecting it to be done in 30 minutes. And the reason why is because we are going through all these details, and the mediator will know minimal details of a case,
If any,
other than names, because it's on my calendar, right? Before the day of the mediation. And the day of the mediation is that time to work through those finer details, as well as to think creatively with a number of minds collaborating and coming up with a resolution. And you got to be ready for the work. It's an exhausting day. I will say that.
It's exhausting for the mediator too.
Yep.
Because you are listening to both sides who start out very far apart, and then you're trying to bridge that gap, which, hopefully we can do. But so you mentioned earlier that you try to allow a day. I allow a day, and I tell my folks, please allow a full day. We'll finish at 5 or 6 o'clock, but a full day, and let's hope we get done sooner.
Yeah.
Even though I know we're never going to get done before lunch, unless
Yeah.
somebody is just not moving.
Yeah.
On
And when I
something.
say the whole day, let's start at like 9:30.
Yeah, exactly.
Not
9:30,
11.
10. Yeah, exactly.
Unless there's a good reason. And sometimes attorneys will have court in the morning. But
Well, and there's sometimes they may need to have, the children may need to be picked up after school. And a lot of times I'll say to the clients, ask that question at the very beginning of mediation so that if there is a child care issue or something, maybe we have a couple hours to resolve that so you don't have to leave at 2 o'clock in the afternoon.
Yeah.
You can stay.
Yeah. And then worst case scenario, which this has happened as well, is yes, you can schedule another day for mediation.
Yeah, absolutely.
I think sometimes people will get to that 5, 6 o'clock and we're close to resolution, but there's one sticking point. Yes, you can come back to mediation. My only word of caution, though, is sleep and talking to other people could change the face of the negotiations. So yes, maybe going back to my earlier example, maybe the opposing side agreed to you getting Christmas Day every year. I, as a mediator, though, can't guarantee that they will still be on that same page if we come for mediation day 2 in the next day or the next week or the next month.
Right. And, unfortunately, or fortunately, I'm not sure which, the clients of the mediation, so the clients of the attorneys in mediation, they're not bound by confidentiality. So they can talk to anybody outside of us about the case. So yes, when you sent, there's, what do we call it, buyer's remorse? When you purchase something and then the next day you're like, what did I do? But with this case, absolutely. Yeah. Well-intentioned family and friends love it, but be careful because, it's your life, and don't let yourself get railroaded by your well-intentioned friends and family into something that you may not want long-term.
Yeah. Or even after being counseled, you're good with something that has been tentatively agreed upon, and then your friends and family convince you otherwise.
Yeah, absolutely. And the person that wants Christmas every single year, that's great when the kids are little and maybe there's Santa Claus involved. But when those kids are 15,
Yeah.
And you've got a new partner and you want to go to Barbados over Christmas, guess what? You're either taking those kids with you or you're not going, so you do have to be careful what you wish for as well.
Yeah.
So that's why I say that do your prep work ahead of time, do your digging, figure out what your main goals are, what your bottom line is, what you can walk out of here and put your head on the pillow at night and sleep. And that's probably the resolution that, you'll get or something close to it.
Yeah, those are great points. And then I guess the final part of the process is, okay, how we have an agreement. How does it become legally enforceable? And what I'll note here is a certified mediator, again, yes, they may be an attorney, but they cannot draft the formal order or agreement thereafter.
Yeah, and that debate is still happening with the Dispute Resolution Commission. I'm the chair of the section this year, and the commission is still looking at whether or not we can make some of the drafting and editing available to the attorneys. And I think most of that push is coming from superior court mediations and not family court mediators because of the nuances in their world, but hopefully at some point mediators will at least be able to assist with some of the editing, if not actually drafting.
Yeah. And I understand we can do stipulations.
We can't draft them still.
Correct. Rather, they can draft them.
Correct.
And we can, circulate a document that is signed off on, but even the stipulations are not a formal order or agreement. That is just the temporary to, seal the day for that evening, not necessarily the final document you'll be following when deciding what happens to your kids or finances.
Yeah, you're right. It's not. On the stipulations, however, if it is certified by a certifying officer, that stipulation may hold up in court.
Yeah, as a contract.
As a contract.
Yeah,
that's exactly right. So,
that's very true.
But I think that stipulations are a good way to end a day so that if you don't get everything resolved, at least you have in writing what you did resolve so that when you go home and start talking to family, you're not changing your mind.
Yeah, agreed.
Absolutely. But certified mediators cannot draft, cannot give legal advice. If there's someone that's not represented, and there is a formal document that is prepared during mediation, the requirement for the mediator is to actually read it along with the pro se party to make sure that everything is understood and to try and answer any procedural questions about that.
Yeah.
So there's a lot of responsibility for the mediator beyond trying to facilitate an agreement.
Yeah. And one more thing before we go, going back to your comment, which I appreciate, is the mediator is in control of the day. I want to remind people, especially if we're court appointed, yes, we want to get your availability. Yes, we want to try to work with both sides to make sure everyone can show up at the same day, at the same time, at the same location. But if I, the mediator, have been appointed and a judge tells me that something has a deadline, if you don't tell me your availability, I'm going to set it. And if I set it, then there's going to be repercussions from that. Go one step further, even when we're court appointed, there is still a fee. There's a fee for the mediator because we are in a private sector. We don't get subsidies from the government. We don't get donations from individuals to allow us to do our work. There is going to be a fee. And I feel like sometimes, especially if there's a pro se party in a family law case and they're court-ordered to do a alternative dispute resolution or mediation in their property matter, that they think, oh, because it's happening through the court, I don't have to worry about payment. And that's unfortunately not the reality of the circumstance.
It's not. And every confirmation letter I send out, and all mediators I know do the same thing, it's very clear in our letter that there is some payment and what that hourly rate is and what the administrative fee is. And for my cases, if I'm not appointed, but there is litigation, I will ask at the beginning whether or not we can follow the Dispute Resolution Commission's guidelines, which then does put me in charge, keep me in charge of the day. And I explained very clearly to the parties what that means. Like, you don't get to decide when you get to leave.
Yeah.
But I'm not unreasonable. I'm not going to keep you here unreasonably because, chances are I've got other work that I need to do.
Yes.
Right? So it's not like I need you here.
Yeah.
And I think most mediators are the same way.
Yeah. And I think that's in part because we've seen these cases as attorneys, as mediators, from start to finish. And so we're pushing and pulling and telling you, you got to stay because we believe, hey, that amicable resolution goal is still achievable.
Right.
Like, just don't leave without me coming back from the other room because maybe we'll get there. And if we get there, you may not necessarily be happy leaving the mediation, but at least you'll be okay. You'll be okay because we found a resolution.
Yeah, and it's okay to blow off steam. I had a party, he was not represented. No, he was represented. He left my office, stormed out of the mediator's office 4 times. Mm-hmm. And I just watched from the window, and he got in his car, and he was like, I'm not coming back. And so we just waited, and he came back 4 times.
Yeah.
I mean, he just needed to blow off steam, which was totally fine. We let him do it. He came back, and we got it resolved. So, you need to meet people where they are.
Yeah.
Right? So if you need to blow off steam, blow off the steam. Yeah. But it is your last hope to get something resolved without having to pay a lot of money for an attorney to take it to court.
Yeah. And you can still try to negotiate down the line. And I say, of course, you can return to mediation, but if you have trial next week,
you're in trouble.
You're in trouble, and either you have what we call a doorstep settlement, meaning you're on the doorsteps to the courtroom, or you're letting a stranger decide your family's future.
That's right. To your point, a lot of times people will schedule mediations really, really close to the deadline that the court set. But if something happens and they can't meet that deadline, most times when the attorney or the client reaches out to the judge will grant a continuance. Mm-hmm. They don't want to hear these cases. No. They prefer the parties resolve these cases. So they're usually good about extending deadlines, which you need to be mindful of. But the deadline is the deadline.
Yep.
And it's a violation of a court order if you miss that deadline.
Yep. And part of that is because the judges are also answering to the higher ups.
Correct.
Because our higher ups, if you will, do not want to see family law cases dragging on for years and years.
Right, exactly. Yep.
Well, Deb, thank you so much for coming back on the Legal Lounge and sharing such critical information about mediation to the listeners. And we're excited to have you back again.
Yeah. Thanks for having me. I look forward to doing it again sometime soon. Thank you.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.